spent a great deal of time working with NASA. While I was there, I had the pleasure of being able to work with a great team that developed some technology that NASA decided to patent. So I spent hundreds of hours working with IP attorneys preparing what I think still holds the record among software patents in the nation for the number of claims that were approved. So I have that little background tidbit to give you. I came here to Mizzou a bit over a year ago. Started this role February 1 of 2014. And one reason I came to this university is when I was looking at the place from the outside back in the fall of 2013, I saw some extraordinary collaborations going on here. Collaborations that cross boundaries normally are pretty high barriers to people working together. Especially I saw a lot of work in the life sciences here, connected engineering. That boded well, I thought, for the future of this university. I came here last year, began to talk to people, and also met a guy named Hank Foley, you'll see today at lunch. Hank currently is our university's vice chancellor for research and graduate studies. He has another role that will be explained later at our system level, and he was a spearhead back in 2013 to change the policies of our university regarding intellectual property. As you know, most universities do this with their IP. They put their arms firmly around it and say, you may pay us to do the work, but we own it at the end of the day, and you got to pay us again to get the results of it, which is not what most companies want to hear. And I'm very proud that Hank, before I got here, I have no credit I can claim here, was very, very effective at changing our attitude towards relationships with the private sector and really easing the ability of the university to be partners with a private sector firm or firms to take ideas, creativity from our university and to take that into the private sector for commercialization. Part of that is IP policy, part of that is culture. And I think the university offers a great culture in terms of collaboration, again, across the usual boundaries between departments, schools, and colleges. This symposium is bringing together some very interesting people. My last job, I was president of Texas A&M University, and I had the, I can't say pleasure, I had the experience of buying a law school. That was a challenge, and I spent about 2 years doing that and was criticized very heavily because everybody said, quote, too many lawyers, unquote. And I've looked carefully at the data out there, such as it is, and realized that generalization isn't true. There are certainly regions of the country and certainly areas of the practice of law where there is saturation to some extent and jobs are hard to achieve. But I found one shining light everywhere I looked in terms of careers in the law, and that was IP law. I come to Mizzou last year. I began to visit our alums, particularly in Kansas City and St. Louis, and we have a lot of MU law alums there, many of whom are involved with IP law, and they were hungry for graduates, which confirmed what I'd found out back in Texas as well. And so I went to this man right here, probably my first month, maybe, Gary. It was really early in my tenure. And I said, Gary, we've got to get busy on this. Now, I discovered at that point he had already assembled here an extraordinary collection of professors, either with direct or indirect connections to IP law. Not that you graduate an IP lawyer after 3 years of law school, but we had the intellectual capital in our law school to drive us in a particular direction. And I urged him to do something in particular. I said, we need to begin building joint degrees with technical fields. Let's find people who want to get a master's degree, for example, in engineering, one of the sciences, and also want to get a JD at the same time, which accelerates their ability to be attractive to a firm specializing in IP or to be hired by companies, universities, and others who are really engaged in the commercialization enterprise. And so he's been moving on that pathway for a while. We've had conversations with our colleagues in Rolla at Missouri S&T about having their technical degree program master's students engage with us in a joint JD program also. So I see this law school beginning to do something which is very impactful going forward in the area of developing people who are poised on graduation to be able to enter the profession of IP law and be successful almost day one. And that's not what most law schools can do. So I'm very, very pleased about that. So it's my pleasure to welcome all of you here today. I have the distinct honor of introducing the Dean of our law school, Gary Myers. He also holds the Earl F. Nelson Professorship of Law here at MU Law. He's the 16th Dean of our law school and has served since 2012. Prior to coming here, he was at Ole Miss, in our law school there. He then, before that, worked in Atlanta, practiced law there. His JD is from Duke University, a minor school on the East Coast, I guess, and had a great success there while he was in law school, author of many books and many scholarly articles as well. Gary Myers.
Thank you, Chancellor Lofton. I appreciate your comments, and in this instance, you got the law school for free, so I hope I hope you recognize the bargain. I want to welcome all of you today to today's symposium. This is the inaugural event for our new Center for Intellectual Property and Entrepreneurship. It's a center that I hope, as the years go on, will prove to establish the University of Missouri School of Law as a center of excellence in this important and growing field, as the Chancellor has mentioned. This is an area of law that's interesting, exciting, and dynamic. And I hope that today's event will share some of the excitement with the campus community, with lawyers, and with students and others who might have an interest in intellectual property as well as entrepreneurship. These two areas are very closely linked, as I think you'll see in the presentations going forward. I want to tell you a little bit about the direction we're going. This conference will cover all the major areas of intellectual property. Our first main session will focus on trademark and branding. These are important issues in the university setting related to topics such as the trademarks held by the university itself, domain names, and other issues. We'll then turn to copyright law. And I think of copyright law as something that's really of importance and interest to just about everyone in the university community, because we are all users of copyright information, and most of us are also producers of copyrighted material. And so both perspectives are important, and as you'll see from the panel, both topics will be of relevance and importance, and we have 4 speakers who will address those topics. Then at lunch, we have a number of speakers, including our keynote, Dennis Crouch, who is nationally known in the area of patent law. Very excited about that presentation. For the afternoon, we will turn to patent law, a very critical area of intellectual property generally, and an area that's of great importance to the university as it relates to STEM and other research and productivity that can be protected under the United States patent law. Finally, our last substantive session will focus on entrepreneurship and will address the interconnection between the innovation activities that are protected by intellectual property and the entrepreneurship activities that can be produced as a result of commercializing inventions, copyrighted material, brands, and trademarks. And so that will, I think, serve as a nice substantive conclusion to our day's events. Afterwards, we'll have a reception, a chance for people to meet and gather and talk about some of the issues that we addressed in the course of the day. In addition, if you registered in advance for the luncheon, there will be boxed lunches available. I encourage you to get those from outside and bring them back in for our lunchtime sessions. So I'm very excited about this program. Before we get started, I want to thank 3 people, at least 2 of whom I know are in the room. I'd like to thank Dennis Crouch and Jim Levin. First of all, if the 2 of you would stand and be recognized. Dennis and Jim are the co-directors of our new Center for Intellectual Property and Entrepreneurship, and they played a pivotal role in organizing this conference as well as in working to establish the new center. I also want to thank Laura Coleman. Laura, I don't think is here. Laura, are you here? No. I want to thank Laura Coleman, who helped with organizing this event as well, and appreciate everyone coming. My last role at this moment is to introduce the moderator for our first panel, and that would be Jim Levin. Jim is a graduate of Macalester College and Northeastern University School of Law. He is involved both in our Center for Dispute Resolution and our Center for Intellectual Property and Entrepreneurship. So he bridges the two areas in which this university's law school is maintaining a focus and an area of emphasis. So I'm very pleased to introduce Jim, who will introduce the panel that will lead things off. Thank you very much.
Yeah, why don't y'all come up? I think this works. If not, I'll stand up or you can stand up here if you want. There's the second one. Yeah. Get all the technical glitches out. You all set? Okay, I want to welcome everyone here today. Il-Young Lee, Professor Lee, sends his regards. He was called out of town a few days ago, and he was going to be on this panel and moderate, but he does send his regards, but I'm more than happy to fill into his place. Our first panel today, as Dean Myers says, is going to focus on trademarks, and we have it divided into three different areas. Our first speaker, Lindsay Cohn, and I'll give a more fuller introduction in a minute, will speak kind of a general trademarks. Then we have Ellen DeGraffenried, who is with the university. We'll talk more specifically about the university's trademarks and so forth. And then our last speaker, Marianne Lynn, will speak about domain names and so forth. And we'll go for about 45 minutes. We'll try to save some time for questions. So if you do have questions, just jot them down and we'll try to get to you. But first I'd like to introduce the speakers. Lindsay Cohn is a proud Mizzou alum. She graduated from the law school, Order of the Coif, which is among the highest honors, or not the highest honor, in 2001. She earned her Bachelor's of Science in Business Administration with emphasis in marketing in 1998. Lindsay focuses her practice on trademark law, including all aspects of development and protection of trademarks, service marks, and trade dress. She counsels clients on the selection, use, and registration of trademarks around the world. She represents clients in inter partes proceedings before the Trademark Trial and Appeal Board and the U.S. Patent and Trademark Office. She regularly works with counsel outside of the U.S. for trademark searches, registrations, post-registration, due diligence, and international inter partes proceedings. She devotes most of her efforts to the prosecution, licensing, and enforcement of trademarks. Lindsay's the past chair of Patent, Trademark, and Copyright section of the Missouri Bar Association. She's active in the International Trademark Association and is an adjunct professor at WashU in St. Louis. She's counsel, and in the program it says of counsel, but she's of counsel. We apologize for that. At the global law firm of Brian Cave, and she will be celebrating her 10th work anniversary with the firm this summer. Ellen DeGraffenried is Vice Chancellor for Marketing and Communications at the university, where she's responsible for building and enhancing the university's brand across key audiences through a comprehensive strategic marketing and communication program. Ellen was previously Senior Vice President for Communications at Brandeis University, overseeing branding and marketing, media relations, university publications, websites, and such at Brandeis. She spent the majority of her career in higher education and academic medicine, serving as Director of Communications and Marketing at the University of North Carolina, at the North Carolina Lineberger Comprehensive Cancer Center. She oversaw public relations for a $230 million research enterprise, led an integrated communication program engaging donors, supporters, and cancer advocates, and led physicians, consumer marketing of the clinical services at the UNC Cancer Center. She previously was Director of Marketing and Communications at University of Louisville Health Center. Her team has won numerous awards. She earned her BA in history from Indiana, where she was elected Phi Beta Kappa. She received an MA in Russian history from University of North Carolina in Chapel Hill, and an MBA from the University of North Carolina Keenan-Flagler Business School. And then our third guest, our third speaker, is someone who works closely with Il-Young Lee, Professor Lee. She's a student here. She was tops and did #1 in her class in trademarks. She's a graduate from her name is Marianne Lynn. She's a graduate from Truman State University. She's currently a dual degree student pursuing both a Juris Doctor and a Master's in Plant Science. She is the note and comment editor for JESSL, that's the Journal for Environmental and Sustainable Living here at the law school, and published an article in the last issue, and is well versed in trademark law. So with that, I want to introduce our first speaker, Lindsay Cohn.
Thank you. What a pleasure to be here today. Can everybody hear me okay? All right, good. I don't usually speak with a mic, so, what do I know? All right, I'm going to hope that I push the right button on the slides. Otherwise, we're going to go backwards. But
This button.
oh, perfect. Forget about this. So this morning, what we're going to talk about, as Professor Devine had said, is trademark law. And what I'm going to discuss specifically is the selection of brand names, how to search for a appropriate brand name, and the risks and rewards of going through the brand selection process. So from the outset, I think it's important to know what are trademarks, what are service marks, and they're statutorily defined, but basically the definition of a trademark is a word, a name, a symbol, or device that's used to identify or distinguish specific goods from those that are manufactured by others and that indicate the source of those goods. So kind of in layman's terms, a trademark is essentially a brand that distinguishes the products from one company from another and that identifies the source of those goods. So an example of a trademark would be one that probably everyone in Columbia and anyone who's gone to Mizzou would be familiar with, and that's Buck's Ice Cream, the official ice cream of Missouri Tigers. So the brand itself is Buck's. The product that it's associated with is ice cream, and the source that's designated as the owner of the product is the Missouri Tigers, University of Missouri. So that kind of gives an overall explanation what's a trademark. And then what is a service mark? Essentially, a service mark is the same as a trademark. It's just that it designates services. So for example, if you are providing research and development services or consulting services, engineering services, software as a service, anything that's not a tangible item but a service that you as an individual or a corporate entity would be providing would be designated as a service mark. So to give you a few other examples of trademarks and service marks, these are a couple of brands that I have the opportunity to work with at Bryan Cave. So as trademarks, we've got Panavision that's designated on cameras, or some of your grocery products, Full Circle and Top Care, Laura Mercier makeup. You see that these are all brands that are tied to a specific product. Service marks would be something like Neiman Marcus for retail services, or Bergdorf Goodman. Hotel services from the Drury Inn, or Becker Educational for CPA exam preparation services. And what I also wanted to emphasize is that trademarks and service marks don't necessarily have to be associated with a money-making entity or a for-profit entity. So some of the non-for-profit groups that I have the opportunity to work with are X Prize for Innovation and Technology contests, or Altrusa, that's a philanthropic international organization that's definitely nonprofit in services, or the Missouri Botanical Garden that's located in St. Louis, Missouri. So that's kind of a basic background of what trademarks and service marks are, but what we want to emphasize today is what do they protect? And basically there's two different sides to what trademarks and service marks protect. Essentially they protect consumers and they protect businesses. So from a consumer perspective, trademarks are there to protect consumers from being misled or confused, because the public has an expectation of certain quality associated with a brand and goodwill, that when we purchase one specific brand, we know that that's going to perform in the way that we're used to because we've purchased it before, or other people have told us about it. We seek recommendations, and we know the consistency of that brand. But also, the brand names facilitate our purchasing decision. Sometimes somebody tells us, oh, Apple is coming up with this new watch. I've got to have it. It facilitates our purchasing because we know it comes from Apple. So that's the consumer perspective. From a business perspective, brands are there to protect the owner of the mark from unfair competition, so that the owner of the mark has the exclusive rights to use that mark and others shouldn't unfairly compete against them. But likewise, trademarks protect and allow a business to perform and protect the goodwill that they've established and built up in that brand. And then also, from the purchasing side, a trademark provides a vehicle for advertising, like the Gary Pinkel smart car that's in the homecoming parade, a vehicle for advertising so that consumers know and recognize the source of the goods. So trademarks, there are varying levels of brand protection and strength. And at the top of the spectrum, the kind of mark that would be the highest protectability and the easiest to enforce, it's what's called a fanciful mark. An example of a fanciful mark, something that's entirely created and came out of the creativity of the brand production group, would be Xerox, a word that has no other meaning than to serve as a brand name. So those are the strongest because they're the most unique, and no one else has that name except to designate these products or services. Moving down in the spectrum of distinctiveness would be an arbitrary mark. And this is when you take a term that has meaning in the English language, but you designate it for something that's totally unrelated to it. So an example there would be Apple. We know it as a fruit, but designating it for technology products makes it an arbitrary designation. So those are likewise strong brand names. Then you kind of get into the middle spectrum where the brands are a little bit more difficult to protect, and that is a suggestive term, a mark that gives you some suggestion about the characteristics of the product or the ingredients of the product, but doesn't extremely describe those characteristics. So an example would be Tide, used as laundry detergent, and it kind of suggests the washing of the water, the coming in and cleansing, but it doesn't actually describe this is laundry detergent. So underneath that dotted line here is where it gets really wishy-washy, and that's if a brand name is what's considered merely descriptive. It's very difficult to protect a brand that's merely descriptive. First of all, the trademark statute says it's not protectable from the outset, but you can protect it if you've acquired distinctiveness and build up notoriety in it. So some examples of a merely descriptive mark would be photographer.com. Now, looking at the brand, you might think, what could this be? Well, if you were thinking it has to do with a photography referral service, you'd be right on. So what you can see is it's merely descriptive of what the service is that they're providing. So the Trademark Office didn't allow this to be registered as a brand because it's merely descriptive. But a brand that you're probably all familiar with would be Best Buy, that is merely descriptive to say we provide the lowest cost, the best buys that are out there. But because they've built up notoriety and used it substantially exclusively, it becomes an exclusive trademark. And the lowest on the spectrum is what's called a generic term, and that is if you're selling tires and you call them tires, you don't get the exclusive right to call it something that's generic. So when you're selecting marks, it seems like a lot to analyze, but there's really value in protecting a strong mark. And that is you have broader protection. Consumers will recognize the notoriety of the brand and the goodwill associated with it. You have an easier time at registering the mark, and there's less likelihood of disputes or allegations of infringement when you select something that's truly, truly unique. So your goal at the end of the day when selecting a brand is essentially to avoid the likelihood of confusion with prior marks that are out there. And likelihood of confusion is a interpreted term that different courts use to determine whether two marks are close in relationship to one another. There's a series of factors that go into that analysis. Different circuits use different factors, but essentially they come down to what's called the DuPont factors, which is what the Trademark Office uses to evaluate registrability. And basically it's, are the marks similar? Do they look the same? Do they sound the same? Do they have a similar meaning? Do they mean the same thing in other languages? Would the public recognize these two terms as being the same or similar? Are the goods and services similar? Are the products somewhat related? They don't have to be identical, but are they related? Would the public think that they originate from the same source? Because companies that put this product or service out there are likely to put out these other products or services. Are the channels, are the channels of trade similar? Are they advertised in a similar fashion? How long has the prior entity used the mark? How sophisticated are the purchasers? Is this an item that you just pick up at the convenience store? Or is this something you spend millions of dollars on, an industrial product that you do an extensive amount of research and you know who the source of the goods are because you're spending a lot of money on it? And is there actual confusion in the marketplace? So now that we know what a trademark is, we understand the likelihood of confusion, let's put it into practice. And really the reason you need to know what these factors are is because you want to know when you launch a product or a service, are you going to create a likelihood of confusion with others out there? And so in order to determine that, you do a trademark search. And so a trademark search has a couple of different reasons behind it. You want to select a distinctive and protectable mark that's based on the spectrum of distinctiveness, the fanciful, arbitrary, suggestive types of marks. But also you want to avoid confusing similarity with others that are out there. So my suggestion is in selecting a mark, you want to search early in the selection process before you actually adopt that mark and before you put it into practice. And actually have a group of names available to you. Oh, brilliant, isn't it? Yes, indeed. So he has a website. He says, we will ship snow, order your snow today. For $89, you can have 6 pounds of snow. He'll ship it anywhere. And if you want more, you can spend $199. And Kyle came up with the name for his business, shipsnowyo.com. So if Kyle had come to me, we would have talked about all of these different issues with distinctiveness and if that's a strong brand from the outset. On that level, you'd probably think it's somewhat descriptive, telling the public you ship snow. But these are some of the issues that we would have discussed had Kyle come to me, and that is, why did you select the mark in the first place? Does it have certain meaning? Are you already using the mark, or is this something we're going to have an intent to use? Who are the target consumers? How will the products be sold? Who are the competitors? Are we aware of any other brands out there that are using something similar? And are there any designs or colors or unique characteristics to the logo that you're coming up with? And the bottom line, we would do the search in order to determine, is shipsnowyo.com registrable, or is it protectable before use? So I did bring a couple of examples of search reports, and I'll pass these around. These are what we call comprehensive search reports. It's for the same mark, but you can see it's a very detailed level of analysis. From a first step, you can search on the U.S. Patent and Trademark Office website, and they have free searching available. But you want to dig a lot deeper than what's available on the PTO website alone. And you also want to dig a lot deeper than what's out there on the Secretary of State's website for business entities. So these kinds of comprehensive searches look at federal trademark applications, registrations, common law databases, looking at business names, phone numbers, internet domain names, etc. And when you think about the search report, you also need to consider foreign searches if you're collaborating with entities out of the country or you intend to launch internationally. Every country has its own trademark rules, regulations, and registration policies. So you want to keep that in mind and search abroad from the outset. As we talked about, you search in order to determine, does this mark infringe on someone else? And can I protect it? Can I register it? So from the infringement issues, if you say, well, I'll just go use it and see what happens, this is the risk. The risks are there are remedies available under the trademark statute for a company or entity to protect its mark and enforce its mark. They could seek an injunction. They could seize to destroy the infringing products, seek actual damages, defendant's profits, treble damages for willful infringement, attorney's fees, as well as corrective advertising. So the risks are pretty severe. There's the potential loss of product identification and goodwill if you have to rebrand, and there's significant costs in the rebranding effort. So that's the risks. The rewards are pretty significant. You have nationwide priority if you register your mark. You will have the exclusive right to use that mark against others. You can seek those statutory damages, and your mark can become incontestable. So the rewards are quite significant, but more importantly, having a strong mark opens the door to licensing opportunities. And I think that's an appropriate segue. And I will pass these around so that you guys have an opportunity. I'm tied. Thank you.
Thank you very much.
Thank you.
So I like to walk around, and I may do that. So I may use the clicker, if we can.
It's the second button.
Second button. Okay. This is really important, and one of the things that I would encourage university entrepreneurs to do is always try to find a name, work with your marketing person, and do a trademark search early. I did this with the UNC genomic sequencing for cancer, and we spent a little bit of money at the beginning, which people are really reluctant to do, but we had a defensible mark by the end of it. So that was something that was really, that people thanked me for. In academia, we tend to start calling things a name, and then we keep calling it that name, and we've never thought about whether it's good for our target audience. And I'll tell you, the UNC sequencing project that's called UNSEQ, UNCSEQ, originally the principal investigators had an acronym that was DRASTIC. Was their acronym for this particular product. And I said, you really want to persuade a cancer patient to do the DRASTIC protocol? I don't think we're going to do that. So it really is important. Here at the university, that's not going to work. So here at the university, again, our goal with our trademark and licensing program is protect, promote, profit, and preserve. And Lindsay talked about protection, profit, just for somewhat, and preservation, and that's what we really focus on. The problem with big public universities like Mizzou, and this is my fourth one and my fifth university overall, is that people tend to think that they have a stake in the university because we are a public entity. And they really play fast and loose with our trademarks, and we have to be very careful about it, and I can talk to you today about some of the ways that we're doing that. The reason we do it is because the college licensing market is 5% of a 93 billion licensed marketplace. And even at 5%, when you're talking about 93 billion, that's a pretty big number. We earn a little more than $2 million a year of unrestricted money from our licensing at University of Missouri, and that has grown very, very quickly in the past few years since we got into the SEC. Sorry, okay, 25% of a $93 billion market. Sorry, collegiate licensing company can't do their own slides. There are professional versus collegiate licensing, and it's really different. There are fewer licenses in professional sports. They tend to be able to control their brand very, very tightly. Anybody here who's worked in academia for more than about 5 minutes knows that trying to control marks, naming, and brand very, very tightly in an academic environment is a losing game. You cannot do that. What you have to do is look at what's happening organically and try to protect it. So we do that quite a bit here at Mizzou. We have a licensed product sales chain. We own the trademark. We license it usually to the manufacturer. They pay the fees through our collegiate licensing company contract, and then the retailer sells. And so you can see kind of what the proportion is here breaking down, but in terms of volume, it's not insignificant money. So our program here started in 1983. I also established the program at Brandeis University, which I came into in 2012 and did not have a licensing program and was not actually protecting its marks except for an occasional cease and desist letter if the general counsel got around to it. But most universities now use a licensing company. We partner with collegiate licensing. There are others that are optimal partners for smaller universities. There are a number of them out there. They do our legal, marketing, enforcement to some extent, paperwork, audit, and corporate responsibility audits, which of course in a college setting are very, very important. We are currently ranked about 19th in the country among collegiate licensing, which is most of the big brands, except for at this point Kentucky and University of Georgia have gone to a competitor. We have just moved it to the Marketing Communications Division. We have an in-house crafters licensing program, which is important in this environment where everybody thinks they own a little piece of us, and I'll talk about that in a minute. And we review over 1,000 license requests and 9,000 art designs per year. Again, we work with CLC. It's the big dog. It negotiates better royalty rates for us. They have a lot of market power, and we appreciate that. These are some of the marks that are on our sheet that we're the owners of. Some of them are marks that we use officially in university branding, and some of them are not. This is very hard for my branding people to understand. They really, really want us all to be using the stacked MU all the time, and they get very discombobulated by the fact that there are a lot of marks out there. But as you all know from Lindsay, and you all know in your everyday practice, if you don't use a mark, you lose it, right? So you don't use it, you lose it. So we license a lot of marks that are not part of our graphic identity or branding standard so that we can protect them. And if all you have is one mark, all you get to sell is one t-shirt or one sweatshirt. So novelty is the name of the game in licensing, and that's why I'm trying to teach our branding people not to freak out when they see the oval tiger head on a lime green shirt, because novelty is the name of the game. So we protect through enforcement. These are some of these things are things that have been seized. Some of these things are things that have not been seized. But we look in retail stores at our bowl games and tournaments. We do a lot of on-site enforcement. We watch the internet and social media and groups and organizations, and we use the likelihood of confusion test as our primary point. Our crafters license program comes here in very handy here. So for people who are selling online on Etsy, for people who are selling Mizzou products on eBay, for people here in Columbia who are making donuts and putting our mark on it, and by the way, the SEC doesn't do this, so we did advise them not to put the SEC mark on a donut. We do a $100 a year crafters license because we are part of the community and we do want to be friendly to small businesses. And we also work with high schools in the state of Missouri who want to use the tiger head mark because we want to be friendly to them. Although we are now starting to clamp down on those outside the state who are using our artwork. There are growth and trends and some weird things we've done here that are a little unusual in collegiate licensing. Who's here has seen the Mizzou Plaid or the Mizzou Paisley? Yeah, so we license those. And then the retro designs that are good for alumni nostalgia, that are not things we currently use in our marketing or in our branding, we do license those. Again, if you don't use it, you lose it. So we keep these licensed. And these College Vault programs this year has been one of the fastest growing product segments for us in the Mizzou licensing program. So policy and legal challenges in the higher ed setting are interesting, particularly in public higher education. One is product type limitations. Like most institutions of higher education, we will not license anything having to do with alcohol or tobacco or firearms. That's pretty obvious. It's not good for your brand. Implied endorsement is another issue. You know, our business policies and procedures manual does not allow the university to endorse for-profit entities. And that becomes a big issue a lot in things like, as Beth Chancellor, who's sitting up here, knows, our IT contracts, because they always ask. And so we all have to keep an eye on that so that we're not implying an endorsement of a public entity for a for-profit entity. And we have to be careful about their use of our trademarks in those settings. Again, the high schools, I talked about that a little bit. And we are currently pursuing international enforcement with a university in Mexico who has even stolen the designs of our uniforms for football, down to the colors, the logo, everything. So we are currently pursuing some international enforcement in Mexico, which is a new thing, a new trend. The internet, you know, it makes everything accessible. You can just take it. Some of the marketing challenges you have with trademarks and licensing at Mizzou is that everybody's special and everybody wants to be different within the university. You know, I always tell my team that consistency is the hobgoblin of small minds and good branding, right? So you've got to be consistent. And we try to keep folks on the academic side using the academic mark, on the athletic side using the athletic mark. Student use is an issue. A lot of times students don't want to use a licensed vendor because they're not selling it, they're giving it away to a club. We are working with the students to think about how they're branding, and they're out there wearing their goods a lot, and we want to ensure that the students are doing the right thing. Again, it's like if we're going to teach our students not to be plagiarists, we probably ought to teach them not to steal trademarks as well. So we do a lot of education. Internal use, again, the licensing, which is very different, and novelty is the name of the game versus the consistency needed for a strong graphic identity. And then in digital applications, social media banners and icons. You can see here some of the more creative things that have come across my desk in the last 6 months since I've been here at Mizzou. We have our paleobiology group, which is, I can't really figure out what's behind the letters. We have equine science, which is a lovely graphic, but really is not where we want to put our brand, literally. And, you know, classical studies, I understand the illusion there, but a three-headed tiger really isn't what we want to be doing. So these are some of the more interesting things that have come across my desk. I did also recently tell the meat market that they weren't allowed to use an offensive or cute slogan with Truman the Tiger, and that's another challenge we have with our students as well. So that's really the overview of how we think about marketing and trademarks, marketing, branding, and trademarks at a university in higher education. It's all about likelihood of confusion. It's all about use it or lose it, primarily. You know, it's somewhat about the revenue, and we're doing a lot of cool things to try to increase that. But, you know, this expertise lives here in your institution. So if you're working with my colleagues here in economic development, you're working with OTT, and you want to think about a name, I know lots of consultants out there who do the market research that comes before the trademark search when you're naming something, and I'd encourage you to get in touch with us because we can help you do that really well.
I want to ask one question.
Okay. We have a question.
Real quickly, I do want to ask one question. So we have people in this room who are developing patents or may have ideas and may want to do startups or entrepreneur, and they're faculty here at the university, so it's really easy to somehow hook that up. What words of advice do you have for them to make sure that they're not stepping on toes or infringing?
If you want to use the Missouri, University of Missouri or the Mizzou name, please come see us first. There are a lot of ways in which we can do that creatively, and I am probably much more open to it than a lot of folks in the branding enterprise in higher education. But, you know, you've got to talk to us about it first, because if we just see it out there in the marketplace, we will ask for enforcement measures to be taken. The other thing that I would say is, again, think about your target audience. You know, God, I love scientists. I've worked with scientists in academic medicine for the vast majority of my career. But again, the drastic protocol wasn't going to be something that cancer patients were going to sign up for willingly. And, you know, we have goodwill with our patients for UNC Healthcare. So UNC SEQ for UNC sequencing was a much more user-friendly name for that particular technology that we were launching. And so I would just encourage you to work with us, and we can help you find resources, and we know people who can do it, who have worked with universities and worked with entrepreneurs before, who can help you find the right name and do it early, because we name things and we keep calling them those things, and those names stick. If you think you need a name for something, I had somebody discover a new cell. They came to me for help naming the cell. If you think you've got something to name, come to us early, because we can help you do that.
Great, thank you. And our third speaker, switching a little bit to domain names. What is it? Sell Snow Yo? I'll turn it over to Ship Snow Yo to Mary Ann.
Some of us don't want it. I moved away from Boston.
Yeah, we can use this button right here.
Hi. Hi. Can everyone hear me? All right. These are my comments on the university and the domain name and domain name dispute resolution. With the rapid expansion of the internet, there have been conflicts over domain names and trademarks that have arisen. So looking at some registered and protectable trademarks of the University of Missouri, those are the University of Missouri, Mizzou, and Missouri Tigers. These have been registered for the use of clothing, educational services, and athletics. So let's take a hypo where someone not associated with Mizzou and without consent registers the domain name uofmizzou.com. And when you click on the link, the domain name resolves to a pornographic site or a website that criticizes the University of Missouri. So the question is, does the content matter, and what can the university do about it? So the university has several options. They can do nothing, they can negotiate and settle, they can litigate, or they can undergo a domain name dispute resolution procedure. I'll be focusing on the domain name dispute resolution. So ICANN, the Internet Corporation for Assigned Names and Numbers, is an internationally organized nonprofit organization that basically manages the internet. They implemented the Uniform Domain Name Dispute Resolution Policy, the UDRP, in 1999 to help resolve conflicts between domain names and trademarks. If you've ever registered a domain name, then you've agreed to the UDRP since it's incorporated into every registration agreement. In the UDRP, it basically requires a mandatory administrative proceeding, and there's a decision by a neutral panel of 1 to 3 attorneys that will decide. ICANN doesn't actually decide or administer the disputes. Instead, there's organizations that do so instead. Some of the administrating organizations are the National Arbitration Forum, the World Intellectual Property Forum Organization, otherwise known as WIPO, and several others located all over the world. The UDRP is designed to address cyber squatting. It's a streamlined, efficient, inexpensive method to resolve dispute. It's cheap because there's actually no discovery, no hearings, and rarely any conferences. Instead, the disputes are usually resolved solely on party submissions. And the panels apply general principles of law, which is especially useful when the parties are in different jurisdictions and or countries. Okay. Going back to the hypo, John Smith, as the person who registered the domain name, would be the respondent, whereas the curators of the University of Missouri would be the complainant. Okay. In the mandatory administrative proceeding under the UDRP paragraph 4A, there has to be 3 elements shown: that the challenged domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights, and the respondent has no rights or legitimate interest in respect of the domain name, and the domain name has been registered and is being used in bad faith. Okay. So all three elements have to actually be shown for the domain name to be either transferred or canceled. But if any of the three elements aren't shown, then the respondent gets to keep the domain name. If either of the parties aren't happy about the panel's decision, then they have the opportunity to go to court and commence action in a court of competent jurisdiction within 10 days. If they do so, then ICANN won't actually implement the panel decision. So since the panel decision isn't necessarily binding, since the parties are free to go to court, then why bother going through the UDRP? Well, many of the cyber squatters don't actually participate in the proceedings. Instead, they default. Furthermore, the disputed domain names are usually transferred in about 80% of the cases filed, and many of the respondents don't actually challenge the panel decisions in court. Looking at the hypo again, the curators must show that uofmizzou.com is identical or confusingly similar to a trademark in which they have rights in, and that Smith has no rights or legitimate interest in respect of the domain name, and uofmizzou.com has been registered and is being used in bad faith. So applying the examples from earlier of the pornographic site or the criticism site, a pornographic site is usually seen as bad faith and meets the third element, whereas the criticism site is a little more difficult. There's actually a split. So the United States has a robust free speech tradition. So when the panelists are from the United States or the parties are from the United States, it's more likely that a non-commercial criticism site will be seen as a legitimate interest. Whereas if they're not from the US, then it might not be seen as a legitimate interest. So looking at a real life example, in 2002, a law student at the Louisiana State University registered the domain name lsulaw.com. The site included a school calendar, law-related links, and comments critical of the law school. The New York Times ran an article that said, "Welcome to our law school, young man. We'll see you in court." So the Louisiana Law School is giving one of its students an unusually comprehensive legal education. In addition to offering the standard classes and exams, it's suing him. Okay. The lawsuit says the student is trading on the school's goodwill and is confusing people. It asks that he be prohibited from using the site's name and requests an unspecified amount of money and law school's legal fees. Currently, the case has settled and the site resolves to this. So, as a matter of fact, the domain names uofmizzou.com and mizzoulaw.com is available. And if someone registers these, then the university have to decide whether action is warranted. So, looking at mizzousucks.com, that is actually registered in Florida. And when you go to the site, you see this. So in the unflattering verb cases, as I stated earlier, 3 elements must be shown. The second and third elements can usually be met. However, the first element is the one at issue since the domain name has to be identical or confusingly similar. So looking at Mizzou and Mizzou sucks, no one ever associates Mizzou with Mizzou sucks. So does that mean the first element automatically fails and the complainant never wins? Well, the consensus is that for the purposes of the first element, that a domain name consisting of a trademark and negative term would be considered confusingly similar. The first element isn't whether or not the domain name causes confusion as to the source, but whether or not the domain name compared side by side with the trademark is confusingly similar. The addition of a generic or descriptive term isn't enough to distinguish the domain name from a trademark. Furthermore, the addition of a word might not alleviate confusions for internet users whose first language isn't in the name, or first language isn't the language of the domain name. Okay. Finally, in conclusion, if the university or anyone else sees a domain name that might potentially infringe on their marks, then they should consider using the UDRP as an alternative to litigation, since it is streamlined, effective, inexpensive method to address cyber squatting, and there's an emerging UDRP jurisprudence and growing body of law, or decisions. Thank you.
Well, the time of our session is up, but I'm going to use my prerogative as moderator to have us stay up here for a few more minutes and see if there are any questions for any of our panelists. We'll start right here.
I have a couple of questions. The first question I have is back on the international enforcement. Can anyone speak to, I know it's probably varies by country, but in general, what is that process like? Is it more protracted than domestic, you know?
Well, it is generally because there's a lot of translation steps in there. So in general, it is going to take longer. We will generally retain outside counsel to do that. I think I'm on here, so we'll generally CLC will retain outside counsel to do that on our behalf. There are some additional costs associated with it, but in the grand scheme of the revenues that we gain from the trademarks and the cost to register them internationally, the ROI is on the balance of registering them internationally.
So I assume that the dispute with Mexico has not been settled yet.
No, it has not been settled, but we are registering the trademark in Mexico. We are moving, because there it isn't registered, and we're moving forward. We did the search and found that it is eligible for registration, so.
And that's something I will highlight on. Different countries have different rules on trademark registration and enforcement. And in several countries, like Mexico, trademark rights are based on who files first, not necessarily who has rights to the mark like we would think of in the US based on their use in commerce. So in a lot of Latin American countries and in a lot of Asian countries, trademark rights are based on who files first. So if you have an interest in pursuing business there, it is to your best benefit to file as soon as possible. Do a search first. You can coordinate with US counsel who coordinates with foreign counsel. Do a search first. If it appears to be available, file right away. You have to designate the goods and services you're going to use with. But what you find a lot is, just like on the domain side, the cyber squatters, you find trademark squatters who will file other companies' brands, happens all the time. And then we find them and have to pursue enforcement.
So can I have another question then on the domain name? And if I'm getting into stuff you're going to talk about, just tell me the way. Obviously, while there's a site like Mizzou Sucks Up or a site with a Mizzou name in it that's going to a porn site or something like that, time is ticking away. What is our normal first reaction as a university to do a cease and desist order first? Is that generally our first?
Yes.
And then let it go through the process? And how successful are those requests?
Yeah, generally before we move to the uniform dispute resolution process, we will do a C&D and we will try to negotiate if there's a squatter, if there's somebody like that. Generally, it is successful. There's one instance that we're negotiating right now that I can't really talk about, where somebody is definitely infringing, but we're in the middle of negotiation. We do try to be pretty friendly with those negotiations, and we'll ask them to assign the rights back to the university, but in general, we do try to cease and desist letter first and then negotiation. They have been.
And I'll pop in on that. On the domain name issue, as Miriam had mentioned, the content of the site matters. And so the risk of sending a cease and desist before you actually initiate a UDRP or a WIPO action is that they may change the content. And so a lot of times what you find is these kind of sites are just search sites. They don't have any content on them, and as soon as they get a letter or somebody clues them off, then they change the site. We're just talking about something that's descriptive, and so we have appropriate use of it, and it's not brand use and et cetera. Yeah. So that's the risk associated, but because the content changes so regularly, when you become aware of something, you need to take action ASAP, because you could start prepping a dispute, and by the next day when you go to file it, they've already changed content. So,
yeah, there are a couple of different enforcement actions I've been involved in. One at Brandeis, they were using the university's seal for a non-registered, non-accredited for-profit university. So, of course, our C&D letter went with a whole bunch of screenshots of their website, and that was successfully resolved.
One more?
How carefully or closely do you police
Well, the issue with tiger is that tigers by itself is not really protectable. And so it's Missouri tigers or Mizzou tigers that is protectable. And so we do police the latter pretty carefully, but the former tigers used generically is really not something that we can protect. So
Would tiger then, with the colors, be a little bit?
not necessarily with the colors, but if it's close to a registered mark. You know, we have some high schools, for example, who have taken the registered oval tiger head athletics mark and just slightly varied it. And, you know, it's, again, the likelihood of confusion standard applies. And if it's at a quick glance or a first glance looks almost identical or identical, then it is enforceable. And we do ask folks to cease and desist.
And on the policing front, the same research companies that we use to do those kind of search reports that I passed out offer watch services. And so on a weekly basis, for those clients of ours who watch their marks, we get alerted to what's out there on the internet, what domain names have been filed, and what trademark applications that have been filed in the US and abroad. So that's how your trademark counsel is watching, monitoring, and keeping you in the loop as to what's out there and what you want to enforce against. If you file something, we will find you.
And that's what CLC and these other companies do for universities, because they have good processes, they have market power, they have a lot of people, they have a deep expertise.
Okay, I want to again thank our panel. We'll give them a hand in a second. We're running just a few minutes late, so why don't we take like a 5 to 10 minute break at the most and try to be back here at 25:02. So you can stretch your legs. There's coffee outside. But again, I want to thank our panel.